Hello, my name is Michael Tesoro and I prepared this presentation entitled Milking It for All It's Worth, ACCC and Lactalis Australia Pty Ltd. The reason I've called it that is I think there was an element of the ACCC probably milking this case for all it was worth in terms of the number of breaches it was alleged against Lactalis and also in the penalty submissions. But I also think the judge probably milked it for all it was worth, expressing a few gratuitous overt statements about his views about the relevant laws and the way the government approaches its task. So I'll deal with that going on, but I think milking it for all it's worth is probably a pretty appropriate title for this presentation. A bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to Tesoro Legal Consulting for the last 15 years, and I help companies with competition and consumer law matters. I also do some consultancy work for various legal publishers on competition and consumer law. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the background to the presentation, I'll start with the background to the case, then look at the liability decision, which came down in 2022, and it's Justice Derrington was the judge, and then the penalty decision, which came down more recently in 2023, then finish with some commentary. Now, the relevant background is that this is the first enforcement action taken by the ACCC under the Dairy Code. So it's a significant case to see how the provisions work, and it's very prescriptive legislation with very specific requirements of what dairy processors are required to do. Lactalis is one of the largest processors in Australia, and it purchases milk from dairy farmers, largely sold through grocery retailers. And as you can gather, it's a very large producer. It purchased in 2020 950 million litres of milk, which is approximately 11% of total raw milk production in Australia. It contracts with over 400 farmers and it directly employs 2,500 people. So it's a very large business, and it's a much larger global business. Now, the allegations ACCC made, they made four primary allegations. The first was that Lactalis failed to publish its standard milk supply agreements as required under the Dairy Code, which they alleged was a breach of Section 12.2 of the Dairy Code. And this was because they weren't available directly off the website. Rather, dairy farmers would have to email their details through to Lactalis and then be sent a copy of the agreement. Secondly, there was an allegation that the milk supply agreements that were provided to the various dairy farmers were not non-exclusive, so they had an exclusivity requirement, namely that 90% of the milk be sold to Lactalis. So that was alleged to be a breach of Section 12 of the Dairy Code. The third one was an allegation that the supply agreements did not consist of a single document, but rather there were a number of different documents that comprised the full agreement, and the ACCC alleged that was a breach of Section 17 and 22 of the Code. And then finally, there was an allegation that the MSAs, or milk supply agreements, contain clauses which breach Section 34 of the Dairy Code. Namely, they permitted termination by Lactalis of the agreement for a breach by the dairy farmer which was not a material breach. So obviously Lactalis as a process is allowed to terminate an agreement for material breach, but not for a non-material breach, which in this case was saying negative things about Lactalis. Now, in relation to allegation one, Derrington looked at the issues and noted that Lactalis did not publish any standard MSAs on its website, and therefore it was clear contravention of Section 12.2 of the Dairy Code. It wasn't really much of an argument, did not comply with the publishing requirement. The publishing requirements in the code are very straightforward. You need to be able to access the documents, and this process of seeking to email the request through and then be sent the MSA is not consistent with the legislation. Allegation two, the judge concluded that there wasn't a breach of the law there, and the requirement in the agreement was that basically dairy farmers had to supply a minimum monthly volume of 90% to Lactalis, and that was based on the prior year's monthly supply. And Derrington goes through and looks at the word, what prohibit means in terms of exclusive agreement. And he comments there that prevention of something by command pursuant to some authority. And I guess what appears to be the conclusion is that even though there was a 90% requirement, there was still some latitude for dairy farmers to supply product to other suppliers, namely the 10% that wasn't had to be provided to Lactalis. So he concluded that it wasn't exclusive. I think that's probably open to debate. I don't think it has to be entirely exclusive. I think any contract that requires exclusivity would probably breach the code, but that's not the approach that Derrington took. The third related to whether there was a breach of the obligation to provide a document in a single, or provide an agreement in a single document. And here the judge was fairly critical of the ACCC. He rejected their submissions. He said that it's really the ACCC's own gloss on the way the legislation's to operate. And as you can see there at paragraph 109, Derrington says there's nothing in the text, context and purpose of the relevant section 22B or in the Dairy Code which requires that at the time of acceptance of an offer to enter into an MSA, the entire contract must be attached to the correspondence communicating that acceptance. So he took the view that unless there was some specific requirement in the legislation, clearly Lactalis couldn't have breached that particular provision. And as you can see there, it follows that the ACCC has failed to establish the contraventions of sections 17 and 22 by reason of its omission to send a single document to farmers containing entirely the MSA which has been entered into. The final allegation related to the ability of Lactalis to terminate an agreement other than for a material breach. And as you can see, he concluded there was non-compliance with sections 34.2 and 3 if the processor can unilaterally terminate the agreement for other than a material breach, and that was the case in this particular MSAs that were provided. So as you can see, what Lactalis was seeking to do was to give themselves a right to terminate an agreement with a dairy farmer if they engage in any denigration of Lactalis, key customers or other stakeholders, and that was not permitted under the relevant legislation. So by having that clause in there, there was no doubt that Lactalis had breached this particular requirement as well. So I guess the ACCC was successful in 2 out of 4 of its allegations. Now, as you can see, the allegations that were found, the contraventions that were found, firstly, by failing to publish its MSAs in the appropriate way, it breached the relevant provision of section 12.2. And then there was a problem in terms of the unilateral termination. And in this case, there was 2 separate contraventions, because you had the first one in relation to from June 2020, and then you had the other date there from January 2020 to January 2021. So the first breach related to the publishing on the website of MSAs that contained this illegal clause about unilateral termination, and then the second breach was a related breach, was actually entering into MSAs which contained the illegal clause about unilateral termination. So then it came back to the penalty decision, and the ACCC made various submissions on penalty. It did conclude that the first contravention was subject to a penalty of $63,000, so the maximum amount was sought there. And I guess seeking the maximum amount, you'd have to think that based on precedent, primarily the High Court decision in Pattinson, that the maximum is required because it's the only way to ensure that Lactalis actually complies with the law. That's where I think they're milking it a bit, because I guess being the first case on the legislation, seeking the maximum for that particular contravention didn't seem to necessarily follow. Then in relation to the second set of contraventions, what the ACCC concluded there was 9 contraventions, but they comprised a single course of conduct, which I think was appropriate. And again, they believed that there should be a penalty there of $250,000. And then in relation to the final contravention, which was the actual entry into the MSAs with the illegal term, they proposed $1 million penalty for 384 contraventions, but again suggesting that that constituted a single course of conduct. So here they're suggesting total penalties of approximately $1.3 million, which is pretty well the maximum amount you could get for these particular contraventions. Now, Derrington went through the various factors. He looked at whether the conduct was intentional or accidental. And I think he concluded that it was careless or reckless. They did adopt incorrect interpretation, Lactalis, of the law, but it was a reasonable interpretation and can't really punish too much for getting it wrong. The fact that the biggest processor in the country and they were so confused about their obligations is a slight concern. Then they looked at the size of the contravener, and obviously, as I said earlier, Lactalis is one of the biggest producers of dairy products in Australia, 950 million litres, 11% of all the total purchases. And then if you're looking at the revenues there, they're very significant, $1.9 billion in the 2020 and 2021, and the values of the assets are $1.3 billion. So they're saying it's a very large company. Now, the ACCC submitted that consideration should be given to the fact that Lactalis was part of this global group, which held itself out to be the world's largest global food group and had total recorded revenue of 22 billion euros in 2021. And the argument they're sort of making here is because it's such a big parent company, the maximum fine should be imposed. So again, I think this is a suggestion of milking it for all it's worth. I think you've really got to obviously look at the contravener, but also the risk that penalty of a lower amount won't achieve deterrence. And ACCC didn't really get into that factor very much. What the judge concluded here was the appropriate measure was annual profit, not annual turnover. And I think that's open to the judge because contrary to a lot of other provisions of the Australian consumer law and the Competition and Consumer Act, there's no reference to annual turnover as the measure for assessing penalties. So I think it was open to the judge to select annual profit in this particular case. And he's saying that looking at the penalty as a proportion of their annual profit would create a significant sting. Then ACCC made this submission that effectively Lactalis had been leveraging its significant power in the market in the past before the dairy code was introduced, derived a commercial advantage from that, and that accordingly the penalties should be higher due to this prior, unfair conduct. And again, I think this is an example of maybe milking it for more than it's really worth. And Derrington's response was he didn't see why there should be any basis for increasing the penalty because Lactalis might have been engaging in particular conduct before the dairy code was brought in. I think that's probably a fair observation. As you can see there, some insinuation that harm should be inflicted for a fact done before there was a law that forbade it. Well, there's a specific law that forbade it, and arguably there were other laws that might have forbade the use of significant power imbalances such as unconscionable conduct, but Derrington was having no part of it. He didn't think that this argument, particularly without really any evidentiary basis, should result in a higher penalty. And he comments there at the ACCC's submissions are actually sort of contrary to the way a just legal system should operate. Now, the other argument the ACCC made was because it's the first penalty under the code, there should be a much bigger penalty. And again, Derrington didn't accept this. He said there's no reason to treat them more harshly because they're the first. In actual fact, it's the other way around that would make sense. Think that when somebody's prosecuted or taken to court under legislation for the first time, the penalty might be somewhat lower because there isn't a lot of guidance from the courts as to the way the law works. So again, this was a strange submission. I think probably lends to the argument that ACCC were trying to milk this case for all it was worth, and the submissions don't really stack up. And then he makes his comment, he got a bit worked up, I think, Derrington. He said it would be contrary to the fundamental principles of the rule of law were it to be otherwise. The ACCC's invitation to make an example of Lactalis merely because it was the first subject complaint under the Dairy Code should vehemently be rejected. So obviously not only rejecting submission but doing so fairly passionately. Then there was a strange series of paragraphs in the judgment where it seemed to me Derrington was just really minimising the conduct which he'd found to be in breach of the legislation in his liability decision. And he comments there that, well, Lactalis did not altogether fail to publish the MSAs. They substantially fulfil their obligation. So he's sort of minimising what they've done, which is clearly a breach of the legislation. And he also goes on there, he's saying that the conduct was not intentionally, occurred essentially as a result of a particular term having a scope of operation more extensive than it ought to have had. It's not impermissible for Lactalis to want to stop people denigrating its business. So this is in relation to the legal term. He says that effectively he can understand why Lactalis wanted such a clause in there, and it was, I guess, legitimate in some respects, although not consistent with the code. And there he talks about the conduct. He says that it could not be considered egregious or contumelious. He's saying that it's not insignificant, but it can't be characterised in these ways. He said it was an oversight. It was a pretty significant oversight, infecting a lot of people, and clearly they got it totally wrong in terms of the way the legislation worked. He also says that the nature and extent of the contraventions here tended to diminish rather than elevate the seriousness of the contravention. So he's spending a lot of time saying that contraventions aren't that serious, that they're really an oversight, and really excusing a lot of Lactalis's conduct. He also goes here that, and this is a strange argument, because he's effectively saying that because responsibility for compliance was put in the hands of a very senior executive, Mr. Houlihan, and he got it wrong, is actually in their favour. And that's not really the way it works. If conduct's engaged in by senior managers, that is usually a bit of a negative factor in terms of the assessment and penalty. But Derrington puts this factor on its head and says that if compliance with the Dairy Code had been carelessly left as a responsibility of an inexperienced junior employee, then that would have counted against them. So he's put this merger factor pretty well on its head and counted it in favour of Lactalis. Again, he's defending the use of the illegal term to constitute a material breach to terminate the agreements. He's saying, given the ability of people today to spread defamatory, derogatory material to a wide audience through social media and the like, there are very good reasons why an entity in the position of Lactalis would seek to protect its reputation and that of staff or others associated with. And then he comments it's a legitimate commercial choice. So he's again defending the clause, which is clearly contrary to the Dairy Code. It's a legal term. So these arguments seem irrelevant, and it seems that he's counting these things in favour of Lactalis to reduce the size of the penalty. Again, he's saying that there's no evidence that the illegal conduct of Lactalis caused any harm to individuals. He said maybe it distorted behaviour in the market. We don't really know. So again, he's saying that the fact there's no proven detriment means the penalty shouldn't be as high. I don't know if that should actually work the other way, that a proven detriment arising from illegal conduct maybe escalates the penalty, but in this case it seemed to justify a reduction in penalty. Again, here he's talking about the acknowledgement of guilt by Lactalis, and then he comments that there should be no increase in the penalty should be contemplated as a result of Lactalis having contested the ACCC case, including the construction of the code. And I guess this is the way it works. Obviously, you get a discount for not contesting guilt, for fully cooperating with the regulator. So here he's saying that the penalty shouldn't go up because Lactalis decided to contest the case. I think that's probably right. But again, he does provide a lot of justification for Lactalis's position. Again, he's very supportive of the position they took. And again, seems to be minimising the conduct which they engaged in. Again, he talks of the fact that they got these issues wrong does not of itself bespeak a culture of non-compliance. In relation to specific contraventions, it's not irrelevant to note that the person whose obligation it was to ensure compliance was a part of the senior management, which cannot be taken to indicate the importance that Lactalis attributed to compliance. And then he makes a comment that it was largely technical, the breaches, and arose out of interpretation of the code that was not altogether unreasonable. I think it's fair to say Lactalis issued a press release shortly after the judgment came down, pointing to this particular paragraph and saying that their breach was largely technical. So I think here Derrington has gone way too far in terms of minimising the conduct that was engaged in, turning factors around the wrong way. The fact that they could engage in conduct of this nature does suggest their compliance programs weren't up to scratch, but he seems to think that the fact that a senior manager got it wrong was proof that they had a good culture of compliance and were taking their obligations seriously. Further minimising conduct, and this is in relation to the claim by the ACCC that the penalty should be larger because Lactalis is the first company to be taken to court on the dairy code. And again, he gets pretty worked up here. He's saying to follow that submission or to accept that submission would be contrary to the rule of law in this country. The law has to be applied even-handedly to its subjects, and to the extent that the ACCC submission can be understood to suggest anything to the contrary, it ought properly to be rejected. There's very strong on this issue that asking for a bigger penalty for the first breach of the legislation is a fundamental violation of the rule of law in the country. It seems a little bit over the top, a little bit dramatic to me. Now, the adverse publicity order was also sought by the ACCC, and the judge decided not to grant it. But again, here's some funny comments by Derrington, where in terms of saying, well, there's no point granting an adverse publicity order, it's not necessary, fair enough. But here he talks about Commonwealth government regulators being notoriously, exceptionally quick to issue press releases in relation to their success in proceedings that they have instituted. And so he makes a negative comment about Commonwealth government regulators. He also says that an adverse publicity order would amount to further penalisation of Lactalis, exposing it to reputational damage and risk of resulting losses. So he's very concerned about the damage to Lactalis and not necessarily what really should be the goal, which is to achieve general deterrence. And there's some really gratuitous overdicta in the case, which really is of concern. And I've noticed that Derrington tends to do this a bit. I know that in another case he made some extremely gratuitous comments about class action litigation in Australia, very negative comments. And here he's done the same thing, and I really think this shouldn't be occurring. I think if the Chief Justice will be having a chat to him about some of this stuff. So the time is possibly fast approaching for courts to begin working upon the understanding the public guidance documents published by regulators, whether they be state or federal, are notorious for overstatement and overreach. Historically, this so-called guidance has tended to advance policy positions in relation to the scope of the laws under consideration, rather than seeking to explain them in digestible form that is accurate and faithful to the underlying material. So he's having a big criticism of the executive government, of government departments. Almost invariably regulatory guidance, and that's in italics, obviously meant sarcastically, exaggerates the breadth of the laws with which it deals, purporting to extend those laws beyond the limits that the responsible parliaments have set. So again, suggesting that the executive government and government departments are going beyond the voice of Parliament and what the Parliament has said the law is, which again, pretty outrageous allegations. While this might well be entirely unintentional, it is potentially on its way to becoming ubiquitous, and those who operate day to day in regulated sectors of the wider market might arguably be entitled, in the light of this trend, to submit that no adverse inference should be drawn against them in the determination of the appropriate civil penalty merely because they've declined to act strictly in accordance with a regulator's proselytising. So again, very over-the-top comments referring to regulators proselytising. I think this is unnecessary commentary. There's some more, and this is more a criticism, I think, of the legislation. So in the previous passage, he's criticising the regulators, and the executive. Here he's sort of criticising the Parliament. So whatever the philosophical or political merits of the Dairy Code, these being matters on which I make no comment, which is sort of we're grateful for that. It is an instrument that has at its heart the according of benefits to one group, farmers, to the detriment of another group, processors. The government has chosen to shift the balance of the market in favour of farmers and has made it clear that those who fail to comply with the obligations underpinning that shift should face consequences of some severity. So I think the main thing here is he's questioning, I think by implication, the philosophy and political merits of the law. And he's saying, well, I'm not going to comment on whether I agree with the philosophical or political merits of the law, but this is the way the government's chose to go, and I have to follow that guidance. So again, it seems to me pretty gratuitous commentary. And then there's this further comments, as he says there, regulators should not seek to require respondents who are made subject to adverse publicity orders to include in the resulting publications the regulator's own assertions about government law making or policy. So he's critical of what the ACCC wanted to have included in the adverse publicity order. And really all they wanted was in that second paragraph indented there, the Dairy Code was introduced to address systematic power imbalances between dairy processors and farmers to improve visibility and transparency over milk supply agreements. The decision highlights the processors must not undermine protections now provided under the Dairy Code, which is pretty well what the legislation was explained to be seeking to do. So the proposal by ACCC to include that adverse publicity order has gained some criticism by Derrington. And then, as he says, the first sentence may be true, but given the admissible extraneous material surrounding the Dairy Code, the court is required to accept it to be so. However, that does not mean that Lactalis as a processor should be compelled to either promote this policy or purport to adopt it. So a court should not require Lactalis to make these statements in any adverse publicity order. And so, as he concludes, follows a draft statement advanced by the ACCC is not one that Lactalis should be required to send to farmers. So again, I think he's going a bit beyond what he needs to say. Really, if he didn't believe the adverse publicity order was going to achieve any general deterrence, that's a good reason not to make it. But all this other commentary seems to me to be unnecessary. So I guess the final decision on penalty which was made was that pecuniary penalty $50,000 be imposed for the first breach, $150,000 for the second breach, and $750,000 for the last breaches. And somewhat strangely, the ACCC was after 1.3 million. Lactalis was after about 200,000. So he's actually gone pretty much to the figure that the ACCC wanted. He's actually imposed quite a big fine. So it's a bit strange given all the negative comments he made about the ACCC submissions and the further negative comments he's made minimising the conduct of Lactalis and its seriousness. And then he's imposed a fine of $1 million, which is quite a high penalty given the maximum available was 1.3 million. So just a few comments. I think the ACCC did try to milk this case for all it was worth. They went very hard on trying to get the maximum penalties, and I think they focused on things they shouldn't have been focusing on the size of the parent company and the first and the fact it was the first company to be prosecuted under the relevant, or taken to court under the relevant legislation, weren't relevant factors. The key factor, based on the High Court decision in Pattinson, is whether the penalty is going to achieve deterrence, whether the business is going to see it as simply a cost of doing business. And I think the maximum penalties weren't really justified in this particular case. I think Derrington resisted a lot of the ACCC submissions and minimised a lot of the behaviour, but then he imposed quite a large penalty. So it's all a bit confusing, really. I didn't think he should have minimised the conduct as much as he did. He's made liability findings, and then when he gets around the penalty thing, he's basically tries to find a lot of reasons why Lactalis's conduct is not that serious at all. And I think that sort of undermines the Dairy Code to have made those statements. He made a lot of gratuitous over statements, and he tends to do this in his judgments, and I think he's really got to rein that in. It's not appropriate to be making all these comments, being critical of regulators, government departments, the executive, and even the Parliament. Really has to not make these comments and stick to what he needs to do when he's writing a judgment. And somewhat strangely, given all this sort of noise and irrelevant comments and gratuitous statements, the decision sounds probably right. I think a penalty of about $1 million was probably appropriate in the circumstances. The ACCC succeeded on half its case. There were pretty clear breaches of the law. The company was a big company. Didn't necessarily accept the fact that they had breached the law and done so on a number of occasions, and to the detriment of dairy farmers. So I think the $1 million penalty is probably about right. So it's funny, given all the noise and carrying on throughout the judgment, it ultimately comes up to what I think is probably the right decision. So that's all I had. Hopefully, if you've got any questions about this, feel free to give me a call or send me an email. Bye-bye.